become vacant. And then 63 is disqualification on grounds of defection.
How do you distinguish between 62 and 63?
My lord. My lord, now, of course, 62 is qualification and 63 is disqualification, but both these conditions are applicable at the time of entry, at the entry point, which is to say that when a candidate files his nomination papers for Parliament or Provincial Assembly, must be eligible under both 62 and not ineligible under 63.
Mm-hmm.
And subsequently, if once a member gets elected, then again, he must...
No, it doesn't say elected. It says a person shall be disqualified from being elected.
From being elected.
So yes, it's pre-election.
G 62, to, as I said.
63.
G 63 also, it says from being elected.
No,
but
some Article 3 says if he is a member.
If he is a member, then, and if there is anything, for example, now there could be few instances.
If you just, let's go to 62. Certain things are factual.
That's right, sir.
He is a citizen of Pakistan. Either he is or he is not.
And the
Two is age of 25 years. And that's also fact. Either you are or you're not. There's no debate here.
And then being on the electoral rolls of a province, that is also
factual. Now we go to C.
That's again with relation
factual.
To
now comes the more difficult ones.
D to G.
Which are, I imagine, not easy to ascertain. He's of good character.
And which?
Are you of good character, Attorney General? Don't answer that.
No, depends how you see me. That's what I had to say.
Please don't answer that. Okay. Not suggesting anything.
No, but
I'm just saying.
This actually says.
I'm just saying your supporters may say excellent character, and your detractors may say horrible character.
Subjective. How you see, how you perceive what is a good character. What is good character? So it is.
And who will determine it? Who will determine it?
Yes. So that these are also all open-ended.
If you see D, and it goes on to say who not commonly known as one who violates Islamic injunctions. So here it is, you may be in absolute violation of Islamic injunctions, but if it is not known, so okay, so it's a very strange sort of wording. Then we go to E. He has adequate knowledge of Islamic teachings. I don't know how many will pass muster in this courtroom. What level of Islamic teachings we are talking about. And practices obligatory duties prescribed by Islam, as well as abstains from major sins. Okay, now we all pray for forgiveness of our sins. So we are all sinners in that way. He is sagacious, righteous, non-profligate, honest, and ameen. There being no declaration to the contrary by a court of law. Now this is tied up with the court of law clause. The court of law, for instance, the cases before us were people not possessing a degree or producing a fake degree or not a recognized degree. So there is some sort of declaration that this was a stipulation. Now there is another thing inbuilt with that. The Constitution never provided for a degree. That's subordinate legislation. The Constitution did not want you to be a graduate. I think that was inserted in 2008. By Musharraf was then the president.
2002. 2002.
So, but it is not one of the prescribed conditionalities either of 62 or 63.
It was perhaps introduced under clause P, subclause P of subclause 1 of 63. 63(1)P, which permits prescribing additional disqualifications through an act of parliament.
Read it again. P1P kya hai?
He is for the time being disqualified from being elected or chosen as a member of the Majlis-e-Shura, Parliament, or of a provincial assembly under any law for the time being in force.
Now, here the word time being has been used twice. It could have said he is disqualified for being elected. So time being.
Yes.
And it's been used, the word time being has been used twice in this thing. So it assumes it's not a permanent disqualification. I don't know.
That's what the first usage of for the time being actually indicates what my Lord has just observed, that perhaps it is a time-bound disqualification which can be introduced through a statute.
Okay. Now, with regard to the disqualification of, did the law for degrees, the law did not provide a time period disqualification. So the Supreme Court, in the case of Samiullah Baloch, held that since no disqualification period has been prescribed, it will be forever.
So long as the declaration is in the field, the disqualification stays.
And the two be resolved now, if the judgment of the Supreme Court also stands and the law also stands, that till the law came into effect, that may have been the position, but since the law has now occupied the field of legislation and prescribed a particular period of time, unless we hear a challenge to the law, which there is no challenge to the law, then why should we disregard the law? That's one way of looking at it. And we don't need to touch the judgment at all, because at that time, this aspect of the matter had not been legislated upon either in the Constitution or by law. So then the courts kind of filled in the vacuum and said that it should be lifetime because there is no period of disqualification. So Samiullah Baloch judgment stays intact, but the law has come in place and it is in the nature of a non-obstante clause. That's one reading of it. What do you have to say to that?
So the question would be, can the sub-constitutional legislation control the Constitution?
So that is one, and then the second would be, can there be legislative overruling of a judgment without first removing the basis on which the judgment came out? So,
can we go to the judgment now of the Supreme Court?
My Lord,
relevant provisions, whatever you think are relevant for our reading.
Paragraphs, my Lord.
Paragraph 35 है
जी 35 and
444 page पे
जी. So this is PLD 2018 Supreme Court 405.
ये चार जजमेंट जो
one thing is very important.
उनका रेफरेंस है पहले इसके अंदर ना, चार जजमेंट हैं, उसके साथ फिर समीउल्लाह है
जी.
एक इम्तियाज अहमद का केस है, एक अब्दुल गफूर है, एक मोहम्मद खान है और एक अलादीनो भाइयों है.
Aladino Bhayo, first Aladino Bhayo, and then the review which came out later in 2020, and the court took a somewhat different view.
Mr. Attorney General, to nullify Samiullah Baloch, the amendment would have been in the Constitution.
My Lord, that's why I
mean, if you're looking at the basis of the judgment,
the
basis of the judgment emanates from the Constitution. So unless the Constitution were to be amended, Samiullah Baloch could not be undone.
So, because Samiullah Baloch is interpreting a constitutional provision, and Samiullah Baloch basically holds that the declaration which is referred to in 62(1)(f) has to remain in field till such time, the declaration in the field, the disqualification stands. Then what my Lord has observed carries.
There is no time limit provided under Article 62.
So there are no time limits as far as my Lord the Chief Justice had just gone through, took us through clauses A through G. Now, as far as D, E, F are concerned, they are all without any timeline. Now, the question before your Lordship, and it was also argued in Samiullah Baloch. In fact, all the counsels before Samiullah Baloch.
If we consider that through Samiullah Baloch the Constitution has been amended, then the constitutional amendment is required, as per my understanding.
My Lord,
it is interpretation.
My Lord, with respect, Samiullah Baloch also read something into the Constitution which was not provided. And
like, what did they read into the?
My Lord, while comparing now, while examining 62(1)(f), the court held that so long as the declaration is in the field, this disqualification stands. While at the same time, when they were examining 63(1)(h), which is under 63 and relates to moral turpitude, which includes dishonesty, and there is a 5-year time limit, the court took a different view while examining both, and it said that, because there is a personal price that a person has prepared by going to prison, so therefore 5 years is good enough. But what the court did not, or with respect, overlook was that in both cases, the declarations are there. Now in 63(1)(h), there is a conviction which stands. It's only that
it's really a question of interpretation, because what's very interesting, speaking for myself, if you look at 63 G, H and I,
yes.
I mean, most of the heinous crimes, especially against the integrity and sovereignty of the country, and that person can be allowed to contest election. Where there are punishments, he goes through punishments and comes out and contests election. What is a bit odd is that a civil declaration, which is just for some misdemeanor, like misconduct, which doesn't even carry a criminal punishment.
Absolutely.
That carries an absolute bar for the rest of the life. That seems to be a bit odd, because if you commit murder, you commit treason, you commit whatever, you can come back and test election. But if you just forget to write something in the form, you would be out forever.
And